5 seconds. Start. All these appeals pertain to the compensation payable for the lands acquired under three different notifications dated 7th April 1986, 5th June 1992, and 3rd July 1995, issued under Section 4 of the Land Acquisition Act 1894, hereinafter referred to as the 1894 Act, for the lands situated in village Ajronda, district Faridabad, state of Haryana. With a notification dated 7th April 1986, issued under Section 4 of the 1894 Act, the state of Haryana sought to acquire land at measuring 6.97 acres situated in village Ajronda, district Faridabad, Haryana, for development and utilization thereof as green belt on the west of Delhi Mathura Road. The land acquisition officer Vide, his award dated 30th March 1989, determined the market value of the acquired land at rupees 3,38,800 per acre. At the instance of the landowners, references were made under Section 18 of the 1894 Act. The reference code determined the market value of the acquired land at rupees 435 per square yard. With a notification dated 5th June 1992, issued under Section 4 of the 1894 Act, the state of Haryana sought to acquire land at measuring 7.81 acres situated in village Ajoronda, district Faridabad, Haryana, for development and utilization thereof for semi-public use, including institutional use for educational, medical, defense, and administrative purposes in Sector 20B, Faridabad. The collector, with his award dated 2nd June 1995, determined the market value of the acquired land at rupees 4,50,000 per acre. The reference code enhanced the amount of compensation to rupees 392.50 per square yard. With a notification dated 3rd July 1995, issued under Section 4 of the 1894 Act, the state of Haryana sought to acquire the land at measuring 98.66 acres situated in village Ajronda, district Faridabad, Haryana, for commercial, institutional, recreational, and residential purposes. The collector, with his award dated 29th June 1998, determined the market value of the acquired land at rupees 5,85,000 per acre. The reference code enhanced the amount of compensation to rupees 400/480 per square yard. The judgment and award passed by the reference code were the subject matter of appeals at the instance of the landowners as well as the state of Haryana before the High Court. By the impugned common judgment and order, the High Court has determined the market value of the acquired land at rupees 435 per square yard with respect to notification dated 7th April 1986 at rupees 566 per square yard with respect to notification dated 5th June 1992 and at rupees 795 per square yard with respect to notification dated 3rd July 1995. Feeling aggrieved and dissatisfied with the impugned common judgment and order passed by the High Court, the original landowners have preferred the present appeals and have prayed for enhancement of the amount of compensation. Learned counsel appearing on behalf of the respective appellants, original landowners, claimants have heavily relied upon the decision of this court dated 11th March 2019, passed in Civil Appeal number 2736 of 2019, and other allied civil appeals by which, with respect to the very notifications dated 7th April 1986, 5th June 1992, and 3rd July 1995, and with respect to the lands acquired of the very villages, this court has determined the compensation at rupees 435 per square yard with respect to the lands acquired under notification dated 7th April 1986 at rupees 860 and rupees 1210 per square yard for the lands acquired under notifications dated 5th June 1992 and 3rd July 1995 respectively. Therefore, it is prayed to enhance the amount of compensation at par with all those other landowners whose lands have been acquired under the same notifications. Learned counsel appearing on behalf of the state of Haryana is not in a position to dispute the above. However, has opposed the appeals on the ground of delay in preferring the appeals. At the outset, it is required to be noted that Vide orders dated 5th September 2022, the delay in preferring the appeals has been condoned by this court subject to rider that the appellant's claimants shall not be entitled to the statutory benefits including interest on the enhanced amount of compensation for the period between the date of the judgments of the High Court till the respective appeals have been preferred before this court. Even otherwise, considering Section 28A of the 1894 Act, the claimants similarly situated whose lands have been acquired under the same notifications shall be entitled to the enhanced amount of compensation at par with the other landowners whose lands have been acquired under the same notifications. Therefore, keeping in mind Section 28A of the 1894 Act, this court condoned the delay, however, on condition to deny the statutory benefits interest on the enhanced amount of compensation from the date of the judgment of the High Court till the respective appeals have been preferred before this court, considering the interest of the state and to see that there is no additional burden of statutory benefits interest on the state for no fault of the state. Now, so far as the merit of the appeals is concerned, it is not in dispute that with respect to the lands acquired under the same notifications dated 7th April 1986, 5th June 1992, and 3rd July 1995, this court vide a detailed judgment and order dated 11th March 2019, passed in Civil Appeal number 2736 of 2019, Balwant Singh dead through LR Gurbinder Singh versus the state of Haryana and other allied appeals has determined the compensation at rupees 435 per square yard for the land acquired under notification dated 7th April 1986 at rupees 860 and rupees 1210 per square yard for the lands acquired under notifications dated 5th June 1992 and 3rd July 1995 respectively. Therefore, the appellants herein landowners, claimants also shall be entitled to the same compensation as determined by this court as in the case of appellants. Also, the lands have been acquired under the same notifications dated 7th April 1986, 5th June 1992, and 3rd July 1995. Stop.